Good evening, everybody. Welcome to the February 18th Zoning Board of Adjustment regular meeting. My name is Kip Malcolm. I am a regular board member stepping in to open this meeting on behalf of the chair who is not present today. With that being said, moving down to the adoption of the, we've officially called the meeting to order at 6:02. And do I have a motion to adopt the agenda or make changes?
I move that we make changes to the agenda by removing under number 6, organizational rules and procedures, to postpone, and to add appointment of vice chair of the zoning board of adjustment regular meeting.
Let's start with just the first motion. The first motion would then be to remove from the current agenda item 6 under organizational rules of procedure. Is there a second?
I second.
We have a motion and a second. Any discussion? This item has been asked to be removed by staff because we have other items on the agenda that we'd like to take care of and at the recommendation of the attorney. Therefore, with no further discussion, all those in favor say aye.
Aye.
Any opposed? Motion carries. That item is removed. And your next motion was?
To add the appointment of a vice chair to the zoning board of adjustment.
And this is where it gets awkward. There are now a motion to appoint a vice chair.
So, just
On the agenda.
I think the motion is
to add it to the agenda.
add the election of a vice chair of this board to the agenda. And I believe, is it correct that your motion would be to put that at the
First point.
first point before adoption of agenda?
Yeah.
All right.
Okay, so there's a motion to appoint a vice chair as part of the agenda. Is there a second?
I second.
With a motion and a second, is there any further discussion? No further discussion. All those in favor say aye.
Aye.
Any opposed? That item has been added to the agenda. Now, with those two items added, are there any further additions, deletions, or corrections to the agenda? Seeing none, do I have a motion to adopt the agenda as amended?
I move that we adopt the agenda as
Amended.
amended.
There's a motion now to adopt the amended agenda. Is there a second?
I second.
A motion and a second. All those in favor, or sorry, any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? All right, the adopted amended agenda has been approved. So now we'll move into the new item that was added just now, and that is the appointment of a vice chair.
I nominate Kip as vice chair for the zoning board of adjustment.
We have now a motion for me to be the vice chair of the zoning board of adjustment. Is there a second?
I second.
I will abstain from this vote. Is there any discussion? All right, all those in favor say aye.
Aye.
Opposed? Hearing none, I hereby, I guess, appoint myself as vice chair, at least for the night.
Congratulations. No, it's not just for the night.
Well, true. Since the chair is not here tonight, I will be assuming the duties of the chair and running the meeting. Our next item up on the agenda is the approval of the December 17th, 2024 special meeting. Do I have a motion to approve the minutes?
Just one point before, a
Please.
point of discussion. I believe in looking at the minutes that at our last meeting, there was a lot of conversation and a motion to continue Ms. Pavel's appeal to the next scheduled meeting. And then at the end, there was a motion to essentially adjourn. I would to keep consistent, I believe there should be a correction in the minutes that say a motion to, instead of a motion to adjourn, a motion to reconvene at the next scheduled meeting, which I believe was the intent of the board when they made that motion. And so if that is the intent of the motion, I would ask that you adopt the minutes with that amendment to it.
So on page 4, which is section 3, item A on the packet, there is a recommendation by staff attorney to change the adjournment to an actual, basically continuance.
I would do it as, just rephrase it, that it was a motion to reconvene, or to recess, a motion to recess until the next scheduled Board of Adjustment meeting.
So item 9, the adjournment, will then be indicated that this is actually just
A motion to recess to the next
A recess
scheduled Board of
to the
Adjustment
next
meeting.
scheduled meeting, which was last month, which was canceled because of weather, which is now moved to today. With that recommendation, is there, I guess a board member technically needs to make that motion.
That's correct.
I make that motion to add that addition.
You need to ask them to make a motion.
Right.
Is there a motion?
I make a motion to adopt the correction of adjournment to recess until the next scheduled meeting in the minutes.
There's a motion to adopt, or to make the modification. Is there a second?
I'll second.
With a motion and a second, is there any discussion? Hearing none, all those in favor, say aye.
Aye.
Aye. Any opposed? Duly noted. That was an addition to the minutes, so yes, we should still now adopt the approval of the minutes with the amendment. All right, is there a motion to adopt the minutes with the amendment?
I make a motion to adopt the agenda
There's a motion to adopt the agenda with the amendment.
with
Is
the
there a second?
amendments as changed.
Minutes, is there a second?
I second.
There is a motion and a second for the approval of the December 17th, 2024 special meeting minutes. Any discussion? Hearing none, all those in favor say aye.
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 Opposed? And that carries. Now, moving into the old business. Do we have Ms. Pavel on the line or present today? Good evening.
Good evening.
We're now going to retake back up. This was the appeal AA 24-000003 by Ms. Annette Paval for the denial of defense permit SB 24-000044 at Lot 14 Green Ore Street in Rogers Bay Campground, 4021 Island Drive.
Just as a brief summary and reminder of the board, we did have that public hearing, that evidentiary hearing on the appeal where there was testimony, evidence presented, and then I believe you all continued the hearing to the next scheduled meeting for the sole purpose of being able to get additional information from public safety. I believe we have that information, and so I believe I don't believe we need to hear additional arguments or questions and testimony, but I do believe we can ask for the testimony or the evidence that you all had requested, and then if there were any additional questions from board members to either Ms. Hill or Ms. Paval, that can be done, and then you can close the evidentiary hearing and enter into your deliberations on that.
Should we make a motion to reopen the evidentiary hearing, or is it just, since it was a continuation?
Since it was a continuation, I
It is still
believe the
active.
evidentiary hearing is still open so that you can.
Okay, so in continuing on with the appeal, I believe we have a staff report as evidence.
So I would like to introduce into evidence a letter, thank you. I'd like to introduce into evidence a letter from Winston C. Sword, Fire Chief for the North Topsail Beach Fire Department, which is presented on your screen, To whom it may concern, the fence located on Lot 14G Orr Street has no bearing on emergency response. The fence sits far enough from the roadway that it does not obstruct any operations for emergency services. As long as it isn't extended further to the roadway, there are no issues.
Thank you. Does the board have any questions of Ms. Hill in regards to the information from the fire chief? Thank you. Ms. Pavel, do you have any questions or further statements about the fire department's representation of this situation?
No, I don't have any other questions. I submitted a picture.
Yes, we do have the picture, the aerial photo, and the ground level. Those items are pages 7 and 8 on the staff report. And that would be the aerial on page 7.
And just to keep the record clean on this, is it the board's wish that these additional photographs that have been provided be incorporated into the record of the evidentiary hearing?
I have no objection to that. Does Ms. Pavel, would you like these items submitted into the record for this case?
Yes, please.
Without objection, I think we can go ahead and admit them into the record. Ms. Pavel, your property is which one on this overview?
My property is the one which is on the very right corner,
The right upper corner?
right upper corner, and the one which you see right there, yes.
Okay.
So, yeah, that's the camper, and the fence is where you see those 3 posts. That was the fence, the location of the fence of my practically where previously the fence was. That's with 3 pipes and a rope between the 3 pipes, and then the fence with plastic, the one which is from purchased from Lowe's, was installed 18 feet long and 6 feet high. But exactly where you see those 3 posts.
Does the board have any questions about this photo representation? So this appears to have been before the fence was constructed?
Yes, I couldn't do any aerial picture from the fence right now.
That's fine. And then the next photo is from your email, although sideways. That is an accurate depiction of what the fence looks like now, correct?
Correct.
Does the board have any questions? And again, that I believe is page 8 of the staff report.
So yes, that's the vinyl fence.
Thank you.
Thank you.
So now the board has reviewed the evidence. Are there any other questions from the board, the planning director, or other parties regarding this case? Hearing none.
Go ahead.
I was going to say,
Microphone.
so this fence was, it's been a couple months. This fence was put up prior to having a permit, correct? And part of the issue that any fences or anything that's done to the property within that area needs to be permitted, correct? So while the fire chief said this didn't pose a safety hazard, we still had the fact that the fence was put up without a permit.
And I think while that is a matter for the town to address, I don't think that is a matter for the planning board to address. I think the planning board before us is strictly the appeal of
Right.
the finding that the fence basically could obstruct and cause a public safety hazard. I think all the evidence we had heard up to that point.
So just, I think by way of just some clarity, the appeal is the denial of a fence permit. I believe there was a request for the fence permit, and it was the denial of that fence permit that has been appealed to the Board of Adjustment for your consideration. And so looking at the standards for whether a permit should be issued here for this kind of fence is the question that's being presented for the board that you all discussed and heard testimony on at your last meeting.
So this was just extra information that we had asked for at the last meeting. It's still, the question is still posed about the denial.
And before we, because I think right now we're kind of getting into the deliberations phase, before we enter into that phase, are there any additional questions for Ms. Hill or Ms. Pavel? Okay. Is there any additional individuals signed up for the public comment on this hearing?
No, sir.
All right. I do believe that you can provide Ms. Pavel an opportunity to do just a very brief closing statement to close the evidentiary hearing, or you can just move to close the evidentiary hearing to enter into your deliberations. It's however the board wishes.
Could I also ask for just another synopsis from Ms. Hill, just to refresh our memories from 2 months ago?
If that is additional evidence or testimony that you believe would be helpful in your considerations, I think that's fine. I just would caution that we have gone through the process of allowing testimony and cross-examination, that we don't want to necessarily be redundant in
Right.
accepting that evidence. So if we keep it brief synopsis for both Ms. Hill and Ms. Pavel, I think that would be appropriate, assuming there's no objection. Ms. Pavel, assuming there's no objection.
No objection.
Thank you.
I guess one question for staff would be, given the position by the town fire chief, has your position on the approval of the fence application changed?
No.
We're in deliberation.
Now, I figured that would be an evidentiary. Okay, so given that, is there any further evidence, Ms. Pavel, that you would like to present?
I couldn't hear the last thing. What was said, the last?
I posed the question to staff as to whether or not the opinion would change based off of the fire chief's opinion in granting the appeal. And she indicated no, so now we're asking, do you have any further evidence that you would like to present?
Well, the application was submitted in accordance with the ordinance for North Capsule Beach. I followed the guidelines, and the denial for this fence was improperly denied, because there's no reason for a fence permit to be denied when 4.0307 allows that, and 4.0311 allows that as well. So at the last meeting in December, I was asked to provide the location of the fence on the property, and I was also asked to tell the fire department and to have the letter that the fence is not obstructing the street or the fire truck coming to the street. So I absolutely no reason for denial for a fence permit, especially when there are over 51 fences that have been at the campground for years.
I'm having a difficult time understanding her, attorney.
What exactly?
Basically, she's asking, could you just repeat what you said? Your internet might be cutting out just a little bit, causing some audio difficulties on our end.
Okay, would you like me to repeat it?
Please?
And just for the record, Ms. Pavel, we were not able to have the court reporter here this evening. She was unavailable. And so just to preserve a record, if you would talk just a little slow, a little more slowly so that we are recording it. So if there is a need for a transcript, she can use this video to transcribe that.
Yes, absolutely. So I applied for this permit for a fence following the guidelines of Rogers Bay Campground. First, I submitted an application together with a drawing of the location of the fence on the lot. That drawing was approved by the campground property manager, and then I applied for a permit to the town. So inadvertently, in between the approval of the application by the campground and the one which was submitted to the town, the workers by mistake built this fence before the issuance of the actual permit by the town, but the fence was done in accordance with the ordinance for North Topsail Beach. It was in the back of the lot, and I was asked at the last meeting to provide pictures as to the exact location of the fence, as well as to ask the fire department about the fence obstructing passage, to have the letter explaining that it's not obstructing my truck, even though this is not required by the ordinance. So I'm asking for the permit for the fence to be approved.
Thank you. Any other questions? Any other questions from the board of staff or Ms. Powell? Hearing none, I believe, Mr. Attorney, a motion to close the evidentiary portion of this hearing is in order.
Yes, you can close, a motion to close the public hearing on this matter so that you can enter into your deliberation phase.
Is there a motion to close the hearing on this matter?
I make a motion to close the evidentiary hearing part and move to the deliberation.
There is now a motion. Do I have a second?
I second.
With a motion and a second in place, is there any further discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? All right, this hearing is now closed, and we will begin deliberation amongst the board.
So it's staff's opinion that the fence violated the ordinance.
I believe it's not the fence, it's the permit for the fence. And I believe it's conflicting opinions as to whether or not there's an obstruction or a delay between the fire chief and Ms. Hill. I think it's a question of the town ordinance. Forgetting that the fence was even put up, let's go back to somebody is now applying for a fence to be put up in this location in Rogers Bay, which is a very tight area and constitutes a travel trailer and a travel trailer park.
Right.
Those are both outlined, and I don't know which page it is. I have the past report that we had. And then looking
And just for the record, I believe the page numbers for the ordinances that you're citing, Mr. Vice Chair, is page 80 for fences, and then page 81 is the start of the 4.03.11 operating standards for existing travel trailers.
Thank you, yes. Page 80 from the old staff report, 81, 82, and 83. So Going back to, we'll start at page 80 for what I'm looking at. Section 4.03.07 fences says that a zoning permit must be obtained from the zoning administrator for any fences erected in the town. So that requirement, in my opinion, has been met. Moving to 4.03.11 operating standards for existing travel trailer parks. Page 81 basically says shall be constructed in accordance with applicable building codes and maintained in compliance. That's section 5, A5, and A6 says shall conform to any and all applicable laws of the town. Again, these are all facts I think that have been established. Going to page 82, section H, about halfway down the page there, structural attachments to travel trailers are prohibited. Says all structural improvements, which this would constitute a structural improvement, or additions to a travel trailer or used in connection with a travel trailer which might contribute to a delay or the inability to readily remove that or any other trailer from its parking space are prohibited. That is specific to the code. Now the question is, I feel that this is considered a structural improvement or addition to the travel trailer or the lot. Therefore, approval for a fence would be prohibited. It's been represented by the fire chief that it doesn't cause an issue with emergency response, but the code specifically says that it could delay or the inability. Public safety's established, we're fine, but the ability to remove, and I guess if we could put the photo, or if you all have the photo, the overview photo, I guess that's the question is, do we feel that that trailer can be readily removed? I mean, driving here today, you drive by and I see trees blocking some trailers in that have probably been there for so long. So I don't know, you know, how do you balance a tree blocking something in versus a fence? This fence does not appear to be blocking, in my opinion. So I might be contradicting myself a little bit.
However, it's still against the town codes. So that's our big question.
And I guess that's what we have to decide, is where does it violate the town section? It's a structural improvement, which might contribute to the delay or the inability to readily remove that or any other trailer. That's, I think, the key point that we are deciding today on whether or not to grant the permit for the fence. Would a fence put there might contribute to the delay or inability to readily remove that or any other trailer?
Isn't it also the size of the fence is above what it was supposed to be? I thought I remembered that. So that's the exception. It wasn't the fence itself. It was the size of the fence. That it went above and beyond what was allowed. So that's starting, okay, if we allow it, sorry, then that's setting a precedent that everybody can appeal, and anybody could appeal anyway, but other properties could possibly be an issue. And that's why that ordinance is there, I would think.
I'm sorry, but the size is allowed. It's up to 10 feet high, which is
Ma'am,
allowed.
Ms. Pavel, unfortunately, testimony is over. At this point, it's a discussion and deliberation by the board. I appreciate your compassion, but this is our discussion that you can eavesdrop in on.
I think for me, when I come back here and it says fences not over 4 feet high may project into or may enclose any front or side yard, and fences enclosing rear yards may be 6 feet high. And the question is, do we consider that a rear or a side? Because it looks like it's a side, and it appears to be higher than the 4 feet. And that's what we're here, I think, to decide. That's the deciding factor there.
Is there any further discussion from the board? Okay. Hearing none, at this point, I believe the board should vote on whether or not to grant the permit or not. We would then, I believe, are there any other motions or conclusions and findings of fact? Okay, hearing none. Is there a motion to approve or, make sure I get this right. We're voting, the appeal
So
is to put the fence.
So the issue here is Ms. Pavel applied for a fence permit, and that permit was denied. And she is appealing the permit denial. And so it is up to you. What you can do is you can uphold the permit denial, which would in essence be a denial of the permit. You can, so you can uphold the denial for the same reasons that Ms. Hill stated. You can uphold the denial on different reasons if you find those in your discussion, or you could reverse the upholdal, or you could reverse the denial, which would essentially be granting the permit. So those would be your options: to uphold with different reasoning, or reverse and allow the fence with the permit, or allow the permit be issued for the fence.
Okay. So with that in mind, board, does anybody like to make a pertinent motion?
I move that we approve the denial,
Uphold the denial?
uphold the denial of the fence.
I second.
We have a motion to uphold the denial and a second. Is there any discussion on that motion? Any other changes or reasoning other than what has been presented into evidence? Hearing none. The vote is on the upholding of the denial. All those in favor say aye. Aye.
Aye.
Any opposed? Then the permit for the fence has been denied. The denial of the application has been denied. Ms. Pavel, we appreciate your time tonight and previously.
I would like to reserve appeal to Onslow County Superior Court.
And I believe that is your right, as long as you do it within the time frame which I'm not familiar with.
30 days from the
So
notice.
it is, so just, you all had your discussion, you made your motion. I believe at your next meeting, you will then look at the written decision, which is required under the ordinance, that you will then look at a written decision and make any edits you deem fit, and then either approve that written decision. And then I believe they're under the ordinance as well as the statutes, and the appeal rights begin to run at the adoption of that written decision.
Ms. Pavel, you heard that?
Oh, yeah, so when will the written decision be ready so that I can start the appeal to Superior Court?
I believe our next meeting is March. Give me just 1 second to check a calendar. So March 18th is the next regular Board of Adjustment meeting. So that would be when the minutes would be approved. And per the attorney, that would be when the clock starts.
Okay, and it's 30 days to appeal or 10 days?
I would check with your own counsel, but we're hearing 30. So, but it's incumbent upon you, I believe, to verify
That'll be
that.
included in
I-
that'll be included in what they approve.
Typically, it's stipulated in the written decision. However, that is on public record with the general statute, so.
Thank you.
Okay.
Thank you again. Good night. That concludes the old business from previously. Moving on to new business. The next item is case VAR 24000001. The hearing on this matter is a quasi-judicial in nature, and it will be conducted in accordance with special due process safeguards. All persons who wish to testify in this case should have signed up on the special sheet for the hearing. If you have not signed in and wish to speak, please sign in now. All those wishing to speak, please proceed to the podium to be sworn in.
You're going to place your right hand, or your left hand, and raise your right hand, and repeat after me. Do you swear that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Am I supposed to be up here?
In just a minute. You can
Okay.
do it.
Thank you. Mr. Attorney?
So this is a request for a variance, and so I would remind the board that under the statutes and ordinance, what you have to find are specifically 4 elements here. How we'll proceed is the planning director will provide, I believe, staff overview, and then it is the applicant's burden of proof to prove these 4 elements, which is in your staff report on page 3 under findings, where it lists 1, 2, 3, and 4, and that a vote on each of the elements needs to be by 4/5 majority, and in this case, it would be everyone. Would you like me to read the ordinance on variance?
On my script, it talks about the any possible conflicts or withdrawal.
I just want to make sure we frame that what we're doing next is a variance, because we just got finished with an appeal.
Correct.
So, I just
So
wanna-
this is a different,
this,
this is specifically
standard.
on the points of the variance request.
Correct, all right. All right, so at that time, before opening the hearing on the variance, I'd like to give you all a chance to review any possible conflicts and withdrawal from these proceedings if necessary. Any board members who have information or special knowledge about the case that may not come out at the hearing today, please describe that information so that the interested person will know that you can then seek to recuse if necessary. All right, I think seeing none, you can then begin your order of business.
The order of business for this hearing will be as follows. First, the planning director, Deb Hill, will present the staff report. Then we will hear from the applicant and any witnesses. Then we will hear from any opponents to this request. Parties may cross-examine each other, cross-examine witnesses after the witness testifies when questions are called for. If you want the board to see written evidence such as reports and maps or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. We cannot accept records from persons who are not here to testify. Before you begin to testify, please clearly identify yourself for the record. I now open public hearing on case VAR 24-000001 and ask for testimony from staff.
The application is by Mr. Lincoln Tad Scott for the property at 1108, 1112, and 1116 New River Inlet Road, which are Ocean View Shores lots 7, 6, and 5. Mr. Scott is requesting a variance from the UDO Article 5, Section 5.1 for R5 zone properties for the front setback to allow for single-family construction of not more than 2,000 square feet of floor space for each lot. Property zone R5, currently the property is vacant. To the north is zoned R10, single-family. To the east is R5, which is also single-family development. To the south is the Atlantic Ocean, and to the west is R20, which is single-family. There are no site improvements, and the lot size for lot 7 is 18,169 square feet. Lot 6 is 18,444 square feet. Lot 5 is 18,847 square feet. Figure 1 is the Ocean View subdivision lots 7, 6, and 5 that are outlined in red. The purple indicates the R5 zoning. The map source is Onslow County GIS with the 2024 aerial and zoning layer. So the property history: in 1957, Topsail Island Highway bisected the parent tracks 1 through 4, with the relocation of the roadway renamed New River Inlet Road. The oceanfront portions of track 1 through 4 were established as Ocean View Shores by a series of plat exemptions recorded as Map Book 44, page 195 for lots 1, 2, and 3, filed June 17th of 2003. Map Book 46, page 117 for lots 1, 2, and 3. Map Book 44, page 196, lots 3, 4, and 5, filed June 17th of 2003. And finally, Map Book 44, page 197 for the lots 6, 7, and 8. And I highlighted the last two where it's kind of split between lot 5 and then the last one, 6 and 7, which is part of Mr. Scott's application. The property has not been rezoned since the initial R5 zoning district and appears to have remained undeveloped. The future land use map 11B classifies the property as high-density residential. The erosion rate is 3 feet. Please see figure 3 on the next page. And the oceanfront hazard setback for development shall be measured in a landward direction from the vegetation line, the pre-project vegetation line, or the measurement line, whichever is applicable, a distance of 90 feet as determined by Division of Coastal Management, the leading permit officer, or other assigned agent of Division of Coastal Management. For compatibility with the UDO Article 5, Section 5-1 requires a 20-foot front setback for R5 zoning districts. So on August the 9th, 2024, Mr. Scott had applied for a CAMA permit to build a 3-story, 1,908 square foot, not including the deck, single-family residence on each of the 3 lots. His CAMA applications were number 52-24 for 1108, 53-24 for 1108. Sorry, that's a correction. 12. That should be 12. Application number 54-24 for 1116 New River Inlet Road. On August the 12th, Jonathan Lucas, the field rep for NC Division of Coastal Management, denied the applications, citing that the applications were not compliant with the following CAMA regulations. That's included in attachments 8, 9, and 10. First, 15A NCAC 078-306A3A, which states a building or other structure less than 5,000 square feet requires a minimum setback of 60 feet or 30 times the shoreline erosion rate, whichever is greater. 2, the exception available at 15 NCAC 078-039B, because the lot was not platted before June 1st, 1979, in the Onslow County Registry Map Book 44, page 197. Now, the crux of this is that the North Carolina Resource Commission is revising 15A NCAC 078-039B in response to concerns raised about the inability to apply for the exception within the oceanfront setback lots created after June 1st, 1979. These concerns emerged after the repeal of another section, which was 15A NCAC 078-104, which was effective August the 1st of 2022, which had similar provisions for the lots created after June 1st, 1979 that could not meet the required setback. The letters provided Mr. Scott 2 options: either appeal the permit decision or seek a variance. The Division of Coastal management requires that the applicant exhaust all other remedies prior to submitting a variance application to the CRC, which necessitates his variance applications to the Town of North Topsail Beach Zoning Board of Adjustment here tonight. And so figure 2 that I referenced earlier is the sources from Diener's Maps. It's actually diener.maps.arcgis.com with the 2020 setback factors indicating the setback factor of 3.0, which would require the 90-foot setback. The challenge is the effect of the annual erosion rate in an area of 3 feet per year, which are not conditions particular to the applicant's property, but to others as indicated in figure, and I said figure 1, but it's actually figure 2, with the blue outline indicating setback factors 3.0 in the subject lots near the center. Can he not bring that up on, did he leave?
I believe he'll be right back. He's printing.
Okay. All right. So for the findings, in accordance with, I'm going to bring my glasses, so you're going to have to bear with me. In accordance with section 2.0304 of the UDO and North Carolina General Statutes 160D, 705D, a variance shall be granted by the board if evidence presented demonstrates the required findings are made. So I kind of did a little bit differently this time, which for us old people might not be a good idea. But the findings are in the first column, both by the UDO and by the North Carolina General Statutes. And then the middle column is the applicant's response to each one of those conditions. And then the column to the right is staff's analysis based on those conditions. So number 1, unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of a variance, no reasonable use can be made of the property. So I'll take the time and go through each one of these. I'll try to read fast, but on behalf of Mr. Scott, he replies, an unnecessary hardship would result from the strict application of the 20-foot front setback requirement in that the applicant will be prevented from making reasonable use of the lot, which is zoned for single-family homes. The town's front yard setback requirements, together with camera rules, specifically 15A NCAC 07H306A3A, serve to prevent the applicant from building a home on his lot. Applicant plans to seek a variance from the North Carolina Resource Commission to the camera setback rule to get approval to build a home of less than 2,000 square feet, but he is required to first seek relief from local requirements restricting use of the property before applying for a variance from the CRC. Due to a proposed rule change that has been approved by the CRC but not yet enacted, the applicant believes that he has a good basis for granting a variance to the camera rule as it currently stands, but he will be able to reduce the scope of the variance requested from the CRC if the town will permit him to build within the town's front yard setback. So, and my response is that the variance request is not in accordance with the CAMA land use plan or sound planning principles. Promoting the development of properties that have been deemed unbuildable due to either state or local development regulations is inconsistent with CAMA land use policy, policy number 25. The town, in an effort to protect eco-friendly environment that the town has established over the years, may aim to secure lots, either acquisition, grant funded, or donation. These lots may be secured as open space easements in perpetuity. Special attention will be given to acquire properties that have been deemed unbuildable due to either state or local development regulations. And also, CAMA Land Use Policy 52, the town supports relocation of structures endangered by erosion if the relocated structure will be in compliance with all applicable local, state, and federal policies and regulations, including the town's zoning and subdivision ordinances. Relocation of structures should comply with density standards outlined with the future land use map section of this plan. The second condition, the hardship results from the conditions that are peculiar to the property, such as location, size, or topography. hardship resulting from personal circumstances as well as hardships from conditions that are common to the neighborhood or the general public may not be the basis for granting a variance. A variance may be granted when necessary and appropriate to make reasonable accommodation under the Federal Fair Housing Act for a person with a disability. Mr. Scott responds, the hardship results from conditions peculiar to this lot and the other two lots owned by the applicant adjoining this lot based on the topography and location of the lot and the date of enactment of certain camera rules as applied to this lot. There are lots of the same or similar size within the same area with homes on them. And staff's analysis is the hardship is not peculiar to Mr. Scott's property, but applies to all properties where the application of the oceanfront setback requirements of Rule 306A would preclude placement of the structure on a lot created after June 1st, 1979. The hardship is created for Mr. Scott's properties and others by 1. The effect of the annual erosion rate in that area of 3 feet per year as required by 15A NCAC 07H 306A and the oceanfront setback requirements which are not conditions peculiar to the applicant's property but to others as indicated in Figure 2 with the blue outline indicating the setback factor of 3.0 and subject lots in the subject lots are near the center. The appeal of 15A NCAC 07H 104 effective August the 1st, 2022, which had provisions for lots created after June 1st, 79 that could not meet the required setback. Third, the inability to apply the exception 15A NCAC 07H 309B within the oceanfront setbacks for lots created after June 1st, 1979. That the revisions proposed to 15A NCAC 07H 309B by the North Carolina Coastal Resource Commission to apply the exception to lots created after June 1st, 1979 have not yet been codified. The hardship, number 3 for the condition is that the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that the circumstances exist may justify the granting of a variance is not a self-created hardship. So just because he knew it when he bought it that way, that you can't hold that against him. And so it's kind of a nod that his knowledge of the circumstances when they brought the property, just that knowledge alone in him buying the property is not something to hold against him. The conditions and special circumstances do not result, Mr. Scott's response, the conditions and special circumstances do not result from actions of the applicant. The applicant has not yet built on the lot nor done anything else on the lot that would violate or change the application or the rules. Staff's response, the hardship is not a result from the actions taken by the applicant, but as the results of oceanfront setback requirements in Rule 306A that preclude placement of a structure on a lot created after June 1st, 1979. The requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. And Mr. Scott says the variance is consistent with the spirit and purpose of the UDO such that public security is secured, substantial justice is achieved, in that allowing the applicant to encroach into the front setback area, a reasonable amount will strike a balance between allowing the applicant to make reasonable use of the lot by building a modest home upon it and protecting the natural beauty and erosion control of that lot. There will still be sufficient distance between the road and the proposed building area and between the ocean and the proposed building area to protect public safety and minimize the loss of life or property resulting from storms and long-term erosion. Staff's analysis is that the requested variance is a requirement by the Division of Coastal Management that the applicant exhaust all other remedies prior to submitting a variance application to the CRC, which necessitates the variance applications to the Town of North Topsail Beach Zoning and Board of Adjustment. So in a list of the, I'm going to For the sake of reading all these out, I'm just going to propose that the exhibits 1 through, and I have actually 15, 1 through 12 be entered into the record. There was an additional, and I didn't get these until, I think, today. I want to say today. From Mr. Scott Surveyor, but there was, for 13, 14, and 15, there are plats, and we have them available if you're able, are you able to bring those up that I sent you? The boundary survey and preliminary plot plan, and these are all the same, so, but 13 is for lot 5, 14 is for lot 6, 15 is for lot 7, by Charles Riggs, date, and they're all dated June 24th of 2024.
I think just for the record, staff has provided the staff report and analysis from the applicant and the staff analysis, and is asking that the entire staff report, along with exhibits 1 through 15, be included into the record of this evidentiary hearing. Is there any objection to the inclusion of all of those documents, Mr.? All right, the applicant has indicated that there are no objections to including those documents into the record.
So that concludes my staff report, unless you have any questions from me, and I'd certainly like to give Mr. Scott the opportunity, even though I've included his responses in, I would certainly want to provide Mr. Scott the opportunity to address the board.
Does anyone have any questions for the planning director? Actually, I just got one. This revision to the section hasn't been enacted, so
It's not been codified. They've proposed it, but it's not been adopted by the state to be included in with the North Carolina Admin Code. And probably the town attorney might be able to expand on that process a little bit better. That's my Planner 101 explanation for the CRC adopting a change, but it's actually up to the state for them to adopt it or accept it and include it into either the admin code or general statutes.
So I think the way that this is framed is the applicant is seeking a variance from the town's front yard setback to build this house. Now, there is a plethora of reasoning as to why he is seeking that variance, which I think goes into the CRC's rulemaking process. And while I think that is, and it's up to you all to determine whether that is, relevant to your decision making, the central issue is the applicant is seeking a setback to the town's, or is seeking a variance to the town's setback requirements. And so I would really focus on whether the applicant meets the burden for that variance.
for the 20-foot front yard setback. Thank you. Are there any other questions? We'll now hear from the applicant. Mr. Scott? If you want to take the lectern, the red light is on, so you are hot.
Hey, how y'all doing? I'm Tad Scott, with Scott Homes, been building and selling real estate on this island since 1999. And I realize this case is a little bit unusual, a rule that's eventually going to be passed, but it hasn't been passed yet or hasn't been activated yet. And to me, the big hang-up is number 2, the uniqueness of the lots, from what I've read and what my attorney has instructed me to say. And my only real response to the uniqueness of the lots, and I know it's probably not what you want to hear, but if you look at Charles Riggs' surveys, and I didn't even get a copy of the most recent one he sent you, these houses that I'm proposing to build, if you look at the static line and the camel line, I know you use the most restrictive of the two, the front deck of this house will be 77 feet off the dune, okay? And that's with this new rule that's coming out through the CRC. And my point is the house to my left, the house to my right would be closer to the ocean than myself. I would be considerably further back than these other two properties. Get my notes out here. The other uniqueness about these lots, and I know it's not super unique, but these lots are all 0.43 acres or above. I mean, they're almost a half-acre lots. We built a lot of houses on this island. Typically, we're building on 1/10 of an acre. So these are, like 4 times the normal size. And I went back and took some pictures, which I want to give you guys. And it's my understanding, and hopefully I'm giving you correct information, is when the beach was renourished, I want to say in 2011, 2012, I actually had pictures made. I went back to 2012 to show the dune. And then I took current pictures, and the dune has not moved. And the dune has been stable for, 13 years. And that's, to me, the uniqueness of these lots, is they're very large. We're going to be building them way off the ocean. We're going to build them back further than the houses that are there. That's my biggest argument or case on number 2, the uniqueness of the lots. And I've got some, I don't know if y'all want to, I actually took some pictures of, we planted, 2,000-3,000 sea oats there. This was April of 2023. And through the use of fertilizer and other things, within 4 months, I didn't know how many of these to make. This was April of 2023, and in July, there's 4 copies. I just didn't know how many to make.
Okay, we can
But this
pass
is
this
how
down.
much improvement they made in just that period of time, and we've obviously fertilized them more, and it's
Are they?
pretty solid
Some
dune
of them are
structure.
different. We'll pass this down.
And this is what I was talking about earlier. These are the pictures, aerials, I should say. Make sure I got these in the right order. Yeah. The first picture or video aerial was taken 4/27 of 2014. And here's a picture dated 5/22/2024. And if you really look at the houses and you really look at the dunes, they've not moved in 13 years.
Put those up there too.
That's pretty much like I say.
All right.
I've had my meeting done 6 times, and I'm going to sit down and answer any questions I have.
Are there, Mr. Attorney, the items that he has submitted, does there need to be a motion to admit them into, or should we number them? How should we proceed, or just provide them as presented by him?
I think as long as we have a copy that we can keep to put with the staff report that you have incorporated into the record, and then we're acknowledging on the record that the applicant has provided a series of photographs that the board is considering. Again, this is the applicant's burden to show each of these 4 elements is met, and he has submitted, in addition to the staff report and his application, he submitted these photographs for your consideration.
Okay. Mr. Scott, are you okay with these becoming a permanent part of the record? Then are there any objections? Hearing none, we'll accept them as part of the record. I'm just going to peruse them real quick.
There's several copies, obviously.
Yep. Pass those down. Oop, here, this goes on the bottom.
Look at the dune in relationship to the houses, and then look back.
If you wouldn't mind, just to the microphone, just for the record.
Yeah, if you look at the old picture and the new picture, and you look at the houses, you can see the dune is stable.
And I think the matter before the Board of Adjustments is actually the front yard. Do you have anything to say as far as the frontage along New River Inlet Road,
You state the frontage, the street side?
the street side? Right,
I mean, anything that y'all are willing to give me, I will take. I have to go to the CRC in Panama in about 2 weeks to have to turn down here, which I'm assuming you're gonna do. And then I have to make my case in front of them, as if I picked up 2 or 3 or 4 feet or anything I picked up, which makes it a little easier for me, but I don't have a great argument why you should do with a stable dune, and I should have brought a more current picture, because I took some pictures when it snowed, and it's twice as thick as.
And again, I'm sorry, I just wanted to be
The
captured.
the dunes have considered, I fertilize spring and the fall, 10-10-10, and water it, and they've really come a long ways from when I first bought them.
And again, I think, please.
I'm not a contractor or a developer, but without the setback, what size structure would you be able to build?
Well, this is where it gets a little crazy. CAMA, and again, I'm not a lawyer, I have a lawyer who represents me, has apparently implemented a law that if you will build a 2,000 square foot house or less, they're going to let people in the high erosion areas go ahead with that. The problem is they haven't implemented their own rule. And it's my understanding that there's some internal conflict at CAMA. I don't know what it is, why they haven't implemented it, I do not know. It's their rule, not mine. I'm just trying to get them to implement their own rule. And it's kind of unusual and kind of weird, but yeah. That's really what my case is based on. I'm gonna build a 2,000 square foot house or less. You don't have the big pump stations out front. You know, it's a house that's gonna be considerably further back from other houses. If you have a storm, my house isn't gonna be knocking over their houses. Their house are gonna be knocking over my house because they're closer to the ocean considerably.
Are there any further questions for the applicant? All right, are there any questions? Thank you. Are there any questions from the board, the planning director, or other parties? All right, we'll now hear from people in opposing this request. Are there anybody signed up for?
Negative.
Okay. Since there are nobody's in opposition to this, does the planning director have any further comment?
No, sir.
Does the board or any other party have any further questions of staff? Actually, I guess I will. So we're only reviewing the 20-foot setback off of the main road.
That's all that that would be all that you would have the authority, as you do not have the authority over Division of Coastal Management's oceanfront setback. So the request is, and it goes to his application where he's applying for a variance from that 20-foot front required setback.
To me, it appears that all portions of the proposed dwelling are outside of or greater than 20 foot. Is
The way Charles Riggs, is this the most current one you have?
No, there's
He just submitted
the
another
last
one.
three. If you run down to the last three,
So it's my understanding the way Charles did this is when this is how much I would be short with the 90-foot setback. These houses were all engineered, you should have that somewhere, 2,000 square feet, and that includes the deck, 28 by 44. We are 18 feet short of a 90-foot setback. So the 60.
This is actually a 90-foot CAMA setback.
From the road,
Yeah.
I'm looking at the dune, the way. And so this is what these numbers came from. If this rule goes into effect, which I've been told it will, they all will be buildable. They'll have to be denied a local variance.
We're not looking at the, we're not,
Right.
he just had this on there, but we're not looking at this
Yeah.
one, we're just looking at these three here.
You're right.
The 20-foot setback starts right there,
Yes.
and then where's the 90-foot setback? Or the vegetation line?
Yeah, that's
And so this-
CAMA and your setbacks, and I think this is improved, the newest thing Charles gave you, but this has probably gotten a little bit better, better, bigger, I should say.
Well,
Not true?
if this is the 90-foot
The-
CAMA small,
the blue line appears to be, if you look at the,
that's the static line.
Okay.
okay.
I think I'm talking in the front, you're talking the back, but yeah. For your case, we're talking about just some kind of,
Can you can you go to the third from the last? I think it's 12. Oh, it's the one. It's the 3 that I sent, that I emailed you. I'm sorry. Yeah, so we go to lot 5. I can't see from here. You're on it. The furthest one to the left. That's lot. It's lot 6. So yeah, there you go. So if you take lot 5, there you go. Scoot it down just a hair. There you go. So this is the camera first line of stable vegetation. So if there were a 60-foot setback, that would be the setback line.
Right.
But in this case, it is a 90-foot camera setback with the 20-foot setback here. So that setback currently is going right through the middle of that proposed 2,000 square foot floor space structure. So his building envelope is really just the point between my 2 arms right there. Does that make sense?
Just for clarity, what I believe you're saying is these surveys depict the houses as they would be built if they were within the 20-foot setback, but the town's 20-foot setback, and it shows that by building it within the 20-foot setback, there is it infringes on the 90-foot CAMA setback. Is that
From the street side.
the correct characterization?
That's correct. And so but if the CRC granted him the variance to the 60-foot line, then he would be able to place each one of those structures within the footprint without the 20-foot setback.
So in the brief summary of the request, you said is requesting a variance, section 5, UDO, Article 5, section 5.1, the front setback. So we're only considering front setback.
That's correct.
And as I see from at least this proposed, it appears that the structure is outside of the 20 feet.
It meets the 20-foot setback.
And all 3 lots meet the 20-foot setback.
That's correct.
And the only matter before us is whether or not,
I know it sounds confusing.
I
It is
believe, I
confusing.
believe what they're asking for is to deviate, not as the plans are presented to you. The plans are presented to you for illustrative purposes.
Correct.
They're saying right now they can't build, and please correct me if I'm wrong, Mr. Scott, but based on your testimony, he's saying, based on CAMA setback and the town setbacks, I can't build the house. And so I'm asking you to vary the 20-foot front setback, which will essentially allow the house to come closer to the road to comply with CAMA's setback. That is the request for the town, correct?
Right.
this is not the proposed where the house would be current, I mean, if, this is only if it were, this is how,
It depends how CAMA rules. Again, it's their rule. If CAMA's rule went into effect today, I could build on these houses, these lots today. But the problem is,
I think Charles, yeah. So right now, I'm in a 90-foot setback, and if I built exactly what I want to build, and they're engineered, you have those plans, I'm 77 feet from the front, so I'm off by 13 feet. Anything you guys gave me on this side, I'll take it, but I'm gonna take it to CAMA and CRC and see if they'll give me the rest of again, it's their rule. I know it's just kind of confusing.
I have one question of the applicant. In the event when the state codifies the CRC's revised 15A NCAC 07H 309B, then Division of Coastal Management staff, the field rep, would be able to issue you an exception and you would not require a variance. Is that correct?
I believe that's correct.
Okay.
Are there any other questions?
If there are no other questions, I believe, and there's no one here to speak in public comment, then I believe that you all can go through the process to close the public hearing portion of this and to enter into your deliberations. And then once you do that, I will outline the variance requirements again.
Okay, so I don't see a well-worded motion for this, but is there a motion to close the evidentiary hearing for this variance request?
I make a motion to close the evidentiary part of the hearing and move to deliberation.
I second.
We have a motion and a second to close the evidentiary hearing. Is there any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Okay.
So just to frame your discussion, I want to make sure that I read from the UDO about variances. This is section 2.03.04 for variances. When unnecessary hardships would result from carrying out the strict letter of a zoning regulation, the Board of Adjustment shall vary any of the provisions of the zoning regulation upon a showing of all of the following. And it lists 4 elements that I'm going to read briefly, the first sentence of each. Unnecessary hardship would result from the strict application of the regulation. Number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Number 3, the hardship did not result from actions taken by the applicant or the property owner. And then number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulation, such that public safety is secured and substantial justice is achieved. And these are reprinted in your staff report on page 3 along the left-hand column. And so what I would encourage the board to do in your discussion, think of those 4 elements, and then if you find the applicant has met their burden for a variance on this front setback, front street side setback, if the applicant has met their burden on an element, that you make a motion on each element under the ordinance, and then discuss it, and then call it to a vote. And with that, I'm going to hand the ordinance that I have printed out to the chair so he can monitor those motions.
So is it the recommendation that we do our discussion before we accept the motions?
Yes, I would go through some discussion and then entertain a motion for the first element, discussion, motion for the second, discussion, motion for the third, and so on.
All right. Any discussion from the board regarding the variance? I mean, I think for me, there's been a lot of talk about the offset off the dunes, the 90 feet, and the provisions of coming. That's not before us at this time. I think the only thing before us is 20 feet. Can we allow variance to go closer to the roadway of 20 feet? In my opinion, I don't think, well, it seems to me that making a provision, we're putting the cart ahead of the horse possibly, but I don't think, I think 20 feet is established and becomes a public safety, becomes a utility, becomes a lot of different things that probably influence the 20-foot setback off of the roadway. So, any other discussion? All right, so having none, we'll go ahead and do motions on each of the elements for the variance as dictated in 2.03.04. The first one, does this, do I have a motion that this is an unnecessary hardship would result from the strict application of the regulation? I know it gets tricky, so my thought is, do you think
Just to interject,
Please.
I believe, based on your discussion, if you all think it's inappropriate, you've heard the elements, and if it is the wish of the board that the applicant has not met his burden as to any elements, that you could then make a motion to just deny the variance, rather than go through each element. If you all, through your discussion, decide that there is not enough substantial and competent material evidence to support a finding of any of these elements.
Okay, so if there are no motions for any of the 4 elements, we will move in. Is there any motion as to the finding of facts, that the descriptions of facts set forth in the staff report and presented evidence to the board, as well as any technical evidence, relevant factors, standards, and the UDO? Having heard all the evidence, do we have a motion?
I'll make a motion to deny the adjustment.
So we have a motion to deny the variance request.
Request.
Is there a second?
I second.
Having a motion and a second, is there any further discussion on this? Hearing none, all those in favor say aye. Aye. Any opposed? The variance is denied.
So I have one question procedurally, because typically when you're saying to bring the ordinance to grant or approve back before the board 30 days later, that would set him back 30 days. And so
I believe
is
that
it possible
in this,
just for him to take his, like I could write him a letter saying that based on,
I believe in this instance, you all have heard the evidence, you've made the discussions, and you have found that the applicant has not met their burden for a variance request here, that you all have denied the variance request. Now, it is required, that denial is to be in writing. And so I do believe that you could entertain a motion to direct the planning director to draft up a simple denial or simple decision denying the request, and then allow the vice chair to sign off on that so that the applicant can have that in writing before any CRC deadlines that he might have.
So, Mr. Scott, is that your request of?
Yeah, the only question I have is, there's 4 burdens approved. I'm sorry, 4 burdens approved. Is this just a blanket denial of all 4?
It is a blanket denial
All 4?
of the evidence presented, correct?
Okay.
Would you like for the director to
Well, no, I just.
issue a letter to the fact that, of the decision?
I'd like to see the 4 reasons. I believe number 2 is kind of the big issue, the uniqueness.
Since we've already voted and the matter is disposed of, would you like a letter from the director? Okay.
I'm trying to expedite your.
She's trying to help you out.
I'm trying not to hold you up, because otherwise, if we do it the way that we've been doing it, it would take another 30 days before you got a written response for you to be able to go to the CRC. By asking them if they would direct me to write a response to you, then you have something from the town, and that's not going to hold you up. All right. I know it doesn't seem like I'm trying to help you, but I am.
I also, and again, just for the record, I do believe that based on the discussion that was heard and the motion, there was a request by the chair or acting chair for a motion on the first element, that there was an unnecessary hardship would result from strict application of the regulation. That motion, there was no motion on the floor. And so the fact that there is no motion on that, I believe that that board has determined that there was no evidence. And since it's a 4-element test, you have to have all 4. The fact that you don't find any evidence for the first one is sufficient enough to deny the request.
Thank you. So then, is there a motion from the board that directs the director to issue a letter indicating the findings of this variance hearing tonight?
I so move.
I second.
So having a motion and a second, is there any discussion on the motion? Hearing none, all those in favor say aye. Aye. Any opposed? Thank you. We direct you to then issue that letter to Mr. Scott
Forthwith.
forthwith. All right. Going back to the agenda, I believe that clears our agenda. I do not think we have any matters that need to go into closed session. Am I correct?
I would ask that you go into closed session to consult an attorney just briefly.
Okay.
Under, I believe the general statute is cited.
All right, so pursuant to North Carolina General Statute 143.1811, subsection A, subsection 3, consultation with the attorney, do I have a motion to enter into a closed session?
I make a motion to enter into closed session.
There's a motion. Do I have a second?
I second.
Having a motion and a second, is there any discussion on the motion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, we will go into closed session. We appreciate your attendance here tonight. Thank you.
Okay, I make a motion to go back into open session.
There's
I second.
a motion and a second. Is there any discussion on the motion to enter back into open session? Hearing none, all those in favor say aye. Aye.
I move that we adjourn.
There was none opposed. Now there's a motion to adjourn the regular meeting. Is there a second?
Second.
Having a motion and a second, any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Hearing none. This meeting is adjourned at 7:40 PM.